Welcome everyone to this first online EIA learning event as part of the National Planning Hub's Environmental Impact Assessment Training Capacity Building Programme. This online session is the first, as I've mentioned, and it is very much an introduction to EIA or Environmental Impact Assessment for yourselves, the audience, as planning officers. So welcome if you're here live, and that'll give you an opportunity to ask questions at the end. If not, if you're watching on catch-up as part of a training programme, then welcome, and I hope you enjoy this and the rest of the series. So just a quick continuation of that welcome and to run through the agenda today. I'm Josh Fothergill. I'm leading I'm the external expert leading this process and the training program. I'm a expert in environmental impact assessment, been involved in the field for over 25 years and spent quite a lot of the focus of the last decade on capacity building, be that online training like this, face-to-face training, doing research, undertaking and contributing to guidance documents, etc. I'm also, you might be familiar with me from Scotland's EIA conference that I founded back in 2017, and a number of you may well have been along to that over the last kind of 8 years or so, bar COVID. We've managed to run that free for the last, since 2017 as noted, and always had tickets available through the planning officers. So in terms of what we're going to focus on today, we're doing the welcome, the agenda. I'll do some housekeeping in a moment to just tell you how to ask questions through this Teams portal that we're doing things with. In a few minutes' time, I'll then give you a quick run through of what is the EIA training programme under the National Planning Hub, and of course introduce what the National Planning Hub is. For those of you who don't know. And then at 10:40, we'll get on to the meat of today's session. So the introduction to EIA for planning officers, which will run us through the process in relation to environmental impact assessment, introduces to the various actors involved in the process, and give us a kind of summary of each of the different steps and some practice in relation to that. We'll have a live Q&A that will be starting around 11:25, and that'll run for about 20 minutes. And then just at the end, a quick next steps in the programme to remind you of what's coming up. So let's get through housekeeping. Your microphones and cameras have been disabled for the session. That just allows us to keep this focused on the training. Be aware that we are recording today's session. That means so it can be shared through the National Planning Hub's EIA web pages, and the slides will also be available for that. But any Q&A that we ask, that you guys ask later on in the process, is going to be excluded from the recording. So, you know, it is planning officers who've been invited to this, and we've curated that. So feel free to ask questions without worry in relation to that. Specifically on the Q&A, within Teams, we are using the Q&A function for that rather than the chat. So it's the button that looks like this that says Q&A under it. And that's where you should pose your questions to me, and we'll then pick those up later on as part of the live Q&A towards the end of the session. So if you do want to ask questions, use that function. You can do that at any time during today's process, and we have staff in the background who are looking at those questions, and we'll curate those. So that's how you move forward on that. We'll read your questions out, so that isn't something you don't have to appear on camera. If you've asked a question, it will be Andy Watts from the Improvement Service who'll be reading those out, and I'll introduce him as part of explaining the project in a moment. If you're having any technical issues, so if you can't hear me for any reason, or you're struggling to see, or any other technical issues, then please use the chat function, and that's the one that obviously says chat under it. So the chat function for technical issues, if it's Q&A for the discussion, then please use the MS Teams Q&A. So the National Planning Improvement Team, here they are, and we, as the EIA training programme, sit off the side here. The National Planning Hub, which sits within the National Planning Improvement Team, is based in and led by the Scottish Government. It's working in partnership with the Improvement Service. And you might be aware of the earlier work around the hydrogen and housing hubs. And it's basically tasked with providing direct support to yourselves as planning authorities and planning officers to help accelerate decision making and development delivery. Environmental impact assessment was identified as one of the areas, or certainly judging environmental consequences and the links to environmental impact assessment was an area for improvement. So Fothergill Training and Consulting, alongside the legal firm Brady's, have been commissioned by the Improvement Service to deliver this environmental impact assessment capacity building training program, and that is all going to be part of and fits in with the National Planning Hub. And there's already some holding pages on the website page for that. So in relation to the EIA training that we're going to be delivering, the first part, the first phase is what we're in now with this first webinar, and one that's going to be available in a couple of weeks' time. So startup and the initial EIA support package before the end of 2025, with a kind of EIA enhancement package building on the core learning of the process and some of the key legal aspects. And that will then run for the first 3 months, the first quarter of 2026. One of the things we've been doing over the last month is engaging, so better defining your EIA training needs. So not quite a full training needs analysis because of the nature of the program we're working to, but we've conducted a baseline survey, and I'd like to thank all of those of you who've already responded to that. So over 170 responses. We're also running some online workshops. We do have another one coming up for EIA confidence officers, planning officers, which is on the 12th of January. I think we're certainly looking for another 5 or 6 planning officers from different planning authorities. So if that is something of interest to you, then you can see the email on the screen there, andy.watts@improvementservice.org.uk. Please email him and he'll be happy to pass on the details. And equally, if you have an interest in possibly discussing a case example of EIA and the potential to develop that into a case study for us to use as part of the National Planning Hub, then we'd be really interested to hear from you as well. And I'm sure we'll repeat that call in future sessions as well. So what are we doing in terms of training delivery? Well, it is all going to be online so that it can be recorded and available to everyone when they need it. So we've got these 2 live online learning events today and one on the 18th of December. The initial Hub's EIA webpage is up and running, and that will be developing and advancing as we move forward. And within that shortly is going to be an EIA process diagram and the same diagram with core regulatory references. And you'll see those on the slides today, but they will be available also on the website. Equally, we've also got our first EIA explainer article, and these are just short articles to help get you comfortable with different aspects of the assessment. And then next year, we'll be having roughly 5 live webinars, far more articles, diagrams, etc. coming forward. So just to give you a quick look at what the hub looks like, I couldn't get the whole page on the screen and make it big enough, so I've had to zoom in a little bit, but on the National Planning Hub webpage, and you've got the link there in the middle of the screen, but if you just Google National Planning Hub or Improvement Service National Planning Hub, you'll certainly find it. So if you click on the EIA section, you've got this holding part at the moment that will be enhanced to cover what we're going to talk about in terms of environmental impact assessment and your learning journey and the information and quick references. But then in terms of the events, they will also appear and be advertised on that event section further down. So you can see there on Thursday the 18th, Neil Collar from Brady's will be doing an introduction to the key EIA legal issues for planning officers. So without further ado, let's move on to the focus of today. So welcome again. This is the introduction to environmental impact assessment for yourselves as planning officers. And what we're going to focus on today in terms of learning objectives very much are introductory aspects. So provide you guys with a core understanding of what is the role of EIA across the planning process. What are the activities within that EIA process, and which of those do the planning authority lead, and which of them do have other parties involved or leading? And of course, looking at who is involved during a compliance EIA process. So the process of EIA will be the focus of today. We will therefore touch on aspects such as screening, scoping, your examination of the EIA report and other content, but we're not going to be giving deep dives on those today. That's something that we'll be focusing on in the second phase in January onwards. So what is environmental impact assessment? Well, I think it's important to start off by indicating it's a decision support tool. It's something that's applied before we get our decision, our consent decision, so before planning permission, and it's only for projects that are likely to have significant effects on the environment. So it isn't something we're going to be applying every day, but it is something that is going to be important for us to be aware about. And it isn't going to be something that is going to basically stop us, although it does have some teeth, but it isn't generally going to stop us from making our consent decision. It is going to be providing information to support that decision. So it will highlight the environmental risks, the environmental opportunities, termed significant effects, and you will take those into account alongside other things as you would any material issues. EIA is focused on identifying, describing and drawing out significance conclusions, and ultimately that is your job as a planning officer when we have an actual EIA development, is to come to the reasoned conclusions on significance at the end and make sure they are fed into the decision process, drawing across the evidence that you have been provided. So it applies to developments, and I guess the key thing to also note is, of course, it's a legislative requirement. So it's applied across the whole of the UK, and it's applied to a number of different consenting processes. But what we will focus on in our discussions and in these sessions is EIA's application within the planning system. So why do we do EIA in the first place? What are its benefits? Well, of course, the environment is already there within the planning system. We have other legislation and there is planning policy as well. But EIA gives us a more rigorous approach to that environmental assessment process of projects for those that carry the greatest risk or greater risk to the environment and equally, in some cases, to our communities. The benefit of EIA is it provides a central voice for the environmental issues. So EIA will tend to have quite a broad scope. The aim is then to focus in on those significant effects, and that can certainly be a challenge, but it does provide a voice across the environmental issues for the applications that come in. But remember, just for those with significant effects. So it's a proactive tool. It's providing the developer who's undertaking their proposal, coming up with their design. It's providing them with information that allows them to apply the mitigation hierarchy to hopefully avoid, prevent or reduce issues before having to look at offsetting. Gives opportunities to think about the environment and integrate that into the design. And of course, for yourselves as a planning authority making the decisions, it's a proactive tool in the fact that it's providing all that evidence and information and therefore giving you greater knowledge and control before you make your consent decision. It's also notably an open tool, so whilst of course the planning system has consultation expectations, the EIA legislation, the EIA regulations also have expectations that need to be met in relation to consultation. So as part of Scotland's commitments under the Aarhus Convention, which is an international piece of law, then and obviously that comes down from that into our requirements with public consultation. It provides opportunities for the public, statutory bodies and others to have a more focused opportunity to think about and raise their concerns or feelings about environmental effects for those projects that pose a greater risk. So it is worth noting that EIA is a long-established regulatory requirement. So it's been in the system since the late 1980s, so it's been around for over 35 years now. So the good thing about that means we have a certain degree of stability in terms of the legislation. As you can see on that slide there, Town and Country Planning EIA Scotland regs have been in place and stable since 2017, so we've had those for over 8 years now. There have been a few amendments along the way, but they aren't really huge substantive amendments that change the process, change a lot of the details. They have been fairly focused, and of course some of those related to us leaving the European Union, which is where the EIA overarching EIA process originated from, certainly for our context. So it is worth noting that EIA also applies to a number of other consenting regimes, as I mentioned earlier. So Section 36 Electricity Works consents via the Energy Consent Unit in the Scottish Government. Marine licensing by the Marine Directorate also sat within the government. And Master Plan consent areas is a new area of EIA that, of course, if you're putting a Master Plan consent area in, often might tend to be in an urban area, and if that is considered to be a project with likely significant effects, then that would also need to go through the EIA process. What I do need to note is that this training and the other sessions within this series will focus on the application of EIA in relation to developments that are seeking planning permission, or equally those that are going through a multi-stage consent process. So that might be planning permission in principle, and then the approval of matters specified in the conditions. So that's going to be our focus of the training. So I did mention earlier that EIA is decision support, and that is absolutely correct, but it does still have some teeth as it's its own set of regulations. So it does prohibit the grant of consent if we don't undertake the EIA process properly or fully. Now, there isn't some kind of magical being that's going to spring up in the planning committee meeting and say, we haven't done everything for EIA, therefore, there's some risk here, we need to not condition it, we need to not consent it. What it effectively means is that consents can be at risk of judicial review if we haven't applied the EIA process correctly. And what that prohibition is the grant of planning permission or that multi-stage consent that I was mentioning. The granting of that to developments that require EIA is prohibited unless an environmental impact assessment has been carried out. Now, that might sound obvious. If it's an EIA development, of course, an environmental impact assessment will have been carried out. But the 2017 regulations have a definition of what environmental impact assessment means, and of course there's further detail within those regulations. So it's making sure that we have effectively project managed the EIA process so that the various activities that we need to undertake have been undertaken, the various consultations have had sufficient time, etc., so that we've actually delivered the full requirements of environmental impact assessment, which will mean that when we do grant consent, if that's what we choose to do, then it should put us in a much better place should anyone come looking to JR our process. So if you want to continue learning particularly about that area and you haven't signed up already, then Neil Collar from Brody's is doing the introduction to key EIA legal issues for planning officers, and that'll be at 10:30 on Thursday, the 18th of December. So in 2 weeks' time from when this one is being delivered live. So if you're interested in that, please do sign up for that, and you can find that on the events page of the National Planning Hub. So moving on, where we really need to start, I think, is the EIA process. And let's build that out from there and be aware of what that is, as this is an introduction to EIA for yourselves. So everything always starts with a development proposal. Somebody wants to do something somewhere. It could be something new. It could be changing something that's already there or something that's already got permission but wants to change that permission, or it could be an extension to an existing development. This could be a public body that is wanting to do something, perhaps some flood risk management works, or it could be, in a lot of cases, it will be a private body that is wanting to bring a development forward. It could be in an urban setting, could be out in a rural setting, could be from the energy, could be from infrastructure, etc. Someone wants to bring a development forward. What we need to do and what the first part of the EIA process is what's termed screening. The planning authority has to decide if an EIA is needed. Now, ideally, the situation will be that the developer will come to you early and make a screening request. However, if they don't do that, then at the point of application, if the project is within the EIA regulations, we'll come on to that in a few slides' time when we're talking about screening specifically. But if the project is within the EIA regulations, called a Schedule 2 development, then you guys will need to screen it. And effectively, you're deciding if EIA is needed, and ultimately the decision there is about whether it's likely to have significant effects or not. So if the answer is no, then we can move straight on to the consent decision. It's going to be dealt with as a normal application. And I guess the key thing to note here is that doesn't mean you forget about the environment. Environmental effects are still taken into account as material considerations. It's just that we're not going with the increased rigor and detail of the EIA process. But of course, what we need to do is assume we've said, yes, there is likely significant effects. We do need to screen this in as EIA development, in which case we will say yes and move across to the scoping phase. It is worth noting that where a developer feels it's very obvious that an EIA will be required for their project, they do have the ability to kind of skip screening and effectively tell you they're going to do an EIA or submit either a scoping request or their EIA report as part of the application. So there is the opportunity for that. So perhaps a wind farm developer, aware that they're very likely to have to do EIA, so they just put themselves into the process. What is scoping? The first actual stage once we've started the EIA? Well, this is all about focusing the assessment and seeking to keep it proportionate. EIA is very interested in likely significant effects at screening, moving on to significant effects through the rest of the process, and that is where we're meant to place our focus. Now, of course, in order to come to that focus, we're going to need to do some research into a number of different environmental areas, and a lot of that sits with the developer and their consultants to find that focus, what methods, what information, what environmental issues, what specific things within that. There is a regulatory opportunity for the developer. It's voluntary, but they can make a scoping request, and then yourselves would have to produce a scoping opinion, and we'll have a slide on that later, and we may well have a whole session focusing on scoping after in the new year. So once we've scoped, it moves on to the assessment side of things, and the assessment side of things is very much in the developer's hands. It will be being led by a group of competent experts who are effectively EIA and various environmental specialist consultants, and they're going to undertake an assessment of the developing design and be feeding into that process so that hopefully the design is open to change. It might be that we can relocate things on site. It might be that we haven't chosen a site yet and we're looking at routing options or those type of things. And the idea is where we find significant effects, we apply the mitigation hierarchy to try and reduce those. All of this gets written up into the EIA report, was previously called an environmental statement. So if you've been around EIA for a long time and not had any recent contact with it, what was known as an environmental statement in 2017 became known as an EIA report. And this is where the applicant presents their findings of their assessment, and there's various formal requirements for this. That must be consulted on alongside the application. So this comes in alongside the submission of the application, and there are consultation requirements that need to be met for the public, for the statutory consultees, various notices that need to be put, and quite a bit of that sits with yourselves as planning authorities. Once we've finished the consultation, we've got the EIA report from the developer, we've got the submission and the application for planning permission. Then as a planning authority, you have to examine all of this, and that's termed the environmental information. So you examine that environmental information to come to your own reasoned conclusions on the significant effects to feed into the consent decision. And if we feel we're comfortable, then we can move on straight to the consent decision. But in some cases, it might be that we feel supplementary information is needed. Part of the consultation might raise gaps highlighted by the statutory consultees. There might be a difference in perspective as to what the significant effects are. And you might feel comfortable and confident to make your reasoned conclusions. That's perfectly fine. Or you may wish to seek supplementary information. And if the answer is yes to that, then we can't move on to decision quite yet. We need to go back and ask for that supplementary information, which may well lead to a little more assessment. The EIA report would need to have some amendments. We'd have to go back through the consultation, and yourselves would have to conduct your examination again. Once we're happy with that and we've looked at those kind of things, we can move on. If once we get to the point where we don't feel any supplementary information is needed, we're on to the consent decision. Those recent conclusions that you have drawn on the significant effects, looking across the EIA report, the consultation findings need to be integrated. And then post-consent, there are various requirements as well. So we need to put some environmental information either within or alongside the decision notice. And if it's a multi-stage consent where we have planning permission in outline, and then we also have the approval of matters specified in conditions, then there may well be a need for some screening in relation to that as well. If we're consenting it, then of course the environmental mitigation that's come from the mitigation hierarchy, monitoring measures, etc., may well need to be turned into conditions. And there are some challenges there, because sometimes the mitigation and monitoring written in the environmental statements for an environmental or a public audience might not be written in a manner that allows them to meet those requirements that you guys have in terms of compliant planning conditions. So sometimes that can be a bit of additional work as well. So that's the EIA process, and that's the core diagram that you guys will have access to on the National Planning Hub. It will be designed slightly differently, but that will be available to you shortly. So we talked and mentioned through that diagram a number of different parties involved in the process. So let's start with yourselves, planning authority, planning officers. Occasionally, it can be the Scottish ministers, but effectively the decision maker. You're the ones who are going to be making EIA's regulatory decisions. So you're going to be making the key decision of screening or in the majority of cases you will, unless the developer applicant decides they're doing EIA anyway. But you will be making the screening decision, you will be making the consenting decision. Therefore, you have a core role in, of course, making those critical EIA decisions. Are there likely significant effects, and therefore EIA is required? And what are those significance conclusions at the back end of the process to feed into the decision, to support that decision as material issues to be considered? Equally, if requested, you can be involved at the scoping process, and in the vast majority of cases, developers will tend to ask for a scoping opinion and use those voluntary powers that they have. The applicant is a key party alongside EIA consultants who they will bring on board and other environmental consultants. So once it's been confirmed that an EIA is needed, they're going to lead, of course, the pre-application activities, and the majority of that work on the top side of the diagram is going to be led by the applicant and their environmental consultants, ultimately leading to the production of that EIA report, which is meant to be a kind of professional expert's perspective on what are the environmental implications of this project. The two other key parties in the live process are the consultation bodies. These are specified in the front of the regulations under Regulation 2, and if a request for a scoping opinion comes in, then you're required to formally consult those during the scoping process, and also there's a requirement for them to be formally consulted once the application and the EIA report become available as well. So they're clearly important parties, but you'll note there is nothing in the legislation, in the regulations, that requires them to be involved in that screening process of deciding whether EIA is required or not. Public and interested parties are the other key party. They're actually only formally brought into the EIA process once we get the application and the EIA report, although of course developers may choose to engage the public and interested parties as part of the earlier process, as part of a scoping strategy, and equally where they're required to do pre-app consultations as part of the wider planning system, they may well and probably will integrate their environmental issues into that. And then finally, the courts can be involved, but that's only if judicial review of a consent awarded for an EIA development is brought in. And as I mentioned, the second session in this series will provide far more focus on the legal aspects of EIA. So let's quickly run through who does what, and we will do this fairly quickly. So the screening process, do we need an EIA or not? It sits with the planning authority, the developer and consultants can be involved in that. They're required to provide certain information, and on occasion they may choose to go straight on to scoping. At scoping stage, what are we going to include in the assessment? What is the methods? What data needs to be gathered? That is led by the developer and the consultants. If they make a request, then you guys have a formal role to produce a scoping opinion, and the statutory consultees need to be engaged in that through a consultation. The impact assessment itself, alongside the design and the EIA report, both of those are led by the developer and the consultants. The consultation process, so once the application has come in with its EIA report alongside it, that's something that you guys have to implement. So various requirements there you guys need to take care of in terms of public notices, in terms of sending it out to the statutory consultees, and of course the statutory consultation bodies and the public are involved as consultees there. But once we get beyond here, the majority of the activities sit with yourselves as the planning authority. So you examine the environmental information, that's the EIA report, the consultation responses. If you decide to make a supplementary request, then of course the developer needs to provide that information, and the consultation bodies and the public need an opportunity to look at that and be consulted upon it. You again would need to undertake and implement that consultation. Once you've finished your examination, you draw reasoned conclusions on the significant effects of the project, and they get integrated into the decision. So if that moves from planning officers to committee, you've got to make sure that's covered in your report. And then, of course, the conditions, any environmental mitigation or monitoring, turning across into conditions. If it's going to be consented, that needs to be produced, and that will fall with yourselves. And then ultimately, the environmental information from EIA to sit alongside. The decision notice, again, is something that sits with you. So very much the majority of the back end of the process is with yourselves, and that front end of the process with the developer really driving through the scoping, impact assessment and EIA reporting phase. And just the red stars, if you've noticed those on there, those are the documents that need to be available on the public record. So we need to be aware that as a planning authority, these type of things need to be available on the public record. So it is a regulatory driven process. There are, of course, details in those regulations to be aware of. So what the second diagram we're making available as part of this introduction to EIA is that same process diagram we had before, but just now with those key references in relation to it. So what is an EIA development? Well, you can find that defined under Regulation 2. There's quite a lot of detail around the screening process, but that is due to different times when you might need to screen a project, if it's a request from a developer, if a project comes in that doesn't have an EIA report but is above the thresholds to be screened, etc., etc. You can see there's a little less regulation here about the components that are being led by the developer, the assessment very much feeding in to or being defined by what is required or what might be required to be covered in the EIA reports that the developer is producing through. But this is really just designed as a quick reference guide to aid yourselves, and you'll be able to access this through the National Planning Hub in order to look at different stages and say, okay, what are the key aspects I need to look at here? Be aware, of course, there are other parts of the regulations that we might need to be aware of at times. So this isn't the only thing you need to be aware of, but at least it gives you a quick reference guide. So I've mentioned on a number of occasions significance as or significant effects as something important in EIA, and it really is fundamental to, I guess, the whole kind of construct of the EIA legislation. We trigger EIA as a result of likely significant effects. We focus the scope and the EIA report on significant effects, and ultimately what yourselves as planning officers draw out as conclusions and feed in to the final decision on the consent process is your reasoned conclusions on the significant effects on the environment of that development if it were consented. So for yourselves as planning officers, We'll certainly go into significance in more detail as we move through this training course, but you always need, as with any aspect of planning, to make reasonable and rational judgments, particularly related to EIA. So you want to be drawing those out of the evidence and making sure that you can justify the decision you've made based on the evidence available. And of course, that isn't just the EIA report. There are the consultation responses, there's internal perspectives from your own planning authority and your own judgments as well. So we need to make sure that we're consulting appropriately to draw out those opinions, but also recognise that it is our own opinion ultimately that matters. And when you come to make your decisions on EIA, making sure they're available on the public record is an important aspect of this, so that everything is open and available as is the expectation through the laws. Ultimately, though, and I know just looking at some of the survey findings, our confidence in EIA across planning officers might not be as where we would like it to be. So I think ultimately, you've really got to recognise it is really using your existing planning judgment skills, those that you're applying every single day to other normal planning applications. We shouldn't get scared of, oh, it's an EIA, oh, what do I do? Oh, it's too complicated. It is really ultimately about you applying those existing planning judgment skills, but this time just in the context of EIA. And hopefully this course in explaining aspects of the process, and in this particular one, introducing those aspects, will help boost some of that confidence. But it's very much your planning skills, evidence-based judgments, drawing out those views, reading across information, coming to conclusions, which is things you do on a daily basis. So another thing I wanted to talk about just in terms of significance was to say, well, how do we build to that significant judgment? And this applies across each aspect of EIA, whether it's historic environment, whether it's landscape, whether it's ecology, cultural habit, various other areas. We always need to understand the baseline. What's the current state of the environmental receptors that are in the vicinity of our projects? That isn't necessarily within the red line boundary. They can obviously be beyond that, or in some cases considerably further away. But we need to understand what's the current state of the environment. We then need to understand what is the change, or in many cases multiple changes, that are going to be brought about by the development. So those changes could be in the construction process. They might only be temporary activities. They could be something in the operation process as well that we need to be aware of and look at. So we bring together, or what the consultants will bring together, and what your thinking and evidence should be looking for is, do we understand the environment? Do we understand the change? And that is what will lead to an effect, the consequence of that change on the receptor within the environment. So that could be on a direct effect on a species, because where the red line boundary and the site of a building will be above some habitat, or it could be something a little bit further away. It could be on setting of a historic monument that is nearby, or it could be on some effects that is going to go into a watercourse and travel downstream to a protected site. Various different effects. We're going to have lots of effects from projects because they interact with the environment. What we need to go on with EIA is this judgment on significance of effect. And ultimately, that is a judgment. It is an evaluation. It's something that is going to be undertaken by the professional environmental experts that are working with the developer. It's something that is going to be looked at and picked at by the statutory consultees and the public. And ultimately, you're going to look across that evidence and come to your own view as to whether you feel there are significant effects or not. So, but they all build up from understanding the environment, the changes from the development, the consequence of that change, and then making a judgment in relation to that. So what I wanted to do now was go back and spend a little bit of time on each of the different areas in the process. Of course, we'll later in this series have a deeper dive, certainly into the screening process that I'm about to talk about, and also into that back end of the process where you receive an application and go through to actually making the consent decision. But what I wanted to do was just go a little bit deeper into each of those in this session as well. So screening is all about whether EIA is required or not. And the first activity that you need to do as part of that process is to decide, is the screening process itself needed? So for certain types of projects, and these are listed in Schedule 1 of the EIA regulations, termed Schedule 1 developments, the law itself has said that these will always have significant effects on the environment. So anything that's listed in Schedule 1 and that is at or above those thresholds is automatically going to require EIA. So it's not going to require you to undertake a screening process as such, because the legislation has already said that that is a requirement. So we can move straight to scoping in that case. And these are very big projects that we might see. So very long, large pipelines, port projects, nuclear power stations, expansions to international airports, etc. Where you guys come in and where screening really takes effect is on these things called Schedule 2 developments. And you won't be surprised to hear that these are listed within the second schedule of the EIA regulations. So if a project meets the requirements of a Schedule 2 development, then you are required to screen it. And the prohibition to give consent to that project isn't removed unless you have screened it. So this is why we can see quite a lot of judicial review in relation to the screening process, because it's quite an early stage and we've got to make sure that we are picking up those projects that are Schedule 2 development. So we need to make a screening proposal. A screening opinion if a proposal is listed in Schedule 2 and it's either at or above the thresholds that are set out in the columns alongside the various descriptions of development in there. So you've got from intensification of agriculture through lots of energy projects and chemical industry projects, etc., into more recreational type activities, infrastructure, and urban development projects, which will tend to pick up housing and other things in the urban area. And then we have thresholds related to those. So for urban developments, if the site is 0.5 hectares or above, then we're going to need to do a screening opinion. The other trigger is if any part of the proposal, any part of the red line boundary is within what's termed a sensitive area. Now, a sensitive area isn't something that you guys get to define. A sensitive area is something that's defined in the regulations. I won't go into the detail today. We'll pick that up in the late January, the third session in this training series. But the first thing to do, is this proposal a Schedule 2 development? If it is, okay, we need to do a screening opinion. That screening opinion effectively has three parts to it. There's the decision itself, there's the opinion that comes from that decision to justify it, and then there's the communication of that, although it's not entirely clear that it has those components within the regulations itself. So we may well produce you a diagram to assist you with that. So the screening decision itself, it's a professional judgment to help you make that judgment as to whether there are likely significant effects. You need to be looking at Schedule 3 and considering the criteria in Schedule 3 of the regulations. And those criteria boiled down look awfully like that diagram I just took you through. They want to understand the development, as in the impacts that might arise. They want to understand the environment and its current status, the baseline, and they want to understand descriptive terms in terms of that effect and the type of consequences. Is it short or long term? Is it temporary or permanent, etc.? And it's combining those issues together that is going to help us come to a significant judgment. So ultimately, as a planning officer, what your job is in terms of deciding whether a Schedule 2 development is EIA development or not is it likely to have one or more significant effects on the environment? And if your judgment is that yes, it is likely to have significant effects, then it's EIA development, and we'll be moving forward with an EIA. If the answer is no, it's just got the standard type of effects that we might expect to see of a development proposal, then it's a normal application. And of course, environmental effects will still be considered as material conditions as part of that normal application, but we won't be going through the detail of the EIA process. Once we've got that decision, then it's for you guys to produce the actual screening opinion. So effectively, it's writing up your above decision, but you need some justification with that and evidence. Now, we're not asking for war and peace here. It is, fairly concise. This is our judgment. This is the evidence. This is why we think there is this risk of significant effects for this one issue or these 6 issues, however many you feel have been the driver of that. But we do need to provide that justification. We can't just simply say, no, it's not EIA, or yes, it is EIA. There is a requirement to justify that. And then finally, the final aspect is communicating that screening finding. So it's making the screening opinion available. Of course, that needs to go back to the applicant, but also placing that on the public record so that if anyone wants to scrutinise that or potentially challenge that from a third-party point of view, it is available. And there is the opportunity to challenge your screening opinions, but that isn't something I'm going to be covering today. We'll pick that up in January. Moving on to the next stage, to the scoping side. This is really entirely about deciding what are the relevant issues for the proposed development and the environment, and it's really defining what is going to be in that developer's EIA report. And clearly, the more we can get that right, the more value and quality that will be to the application process, and the less likely there's going to be delays through a need to ask for supplementary information. So it is going to be the developer and their EIA consultants who are going to lead this in the pre-application process. It's normally going to be pretty broad, and there's likely to be informal consultation occurring in relation to this. So the developers' EIA consultants might well get in touch with yourselves, might well get in touch with the statutory consultees. They can implement and act on, and in many times they will, make a scoping request, but they may have had conversations with you about the project and its environmental implications before that comes in, because oftentimes now we'll scope relatively a little bit later in the design process so that there's much more clarity as to what the project actually is. And that's certainly on feedback from the statutory consultation bodies, that it is hard to define what assessments are needed and what detail is needed if the design or the pre-application design of the project is at a very early stage, and therefore a lot of the details are missing. If they do decide to make that formal scoping request, it is triggering a formal process within the regulations, and that's a process that you guys lead as planning officers. So you're then required to consult the consultation bodies and produce a scoping opinion that you issue to the developer and also place on the public record. We'll focus on more details about that in some of the later sessions. It is notable the statutory consultees aren't required to respond. There's nothing in the regulations that says they have to respond in a certain amount of time. So I'm sure many of you will have experienced challenges where perhaps they haven't responded in the time, and do you wait to issue the scoping opinion or not? Ideally, the sooner we can get some information, some scoping opinion back to the developer, the earlier we're in the process, the more opportunity to potentially influence the design and therefore apply the higher aspects of the mitigation hierarchy to hopefully avoid or prevent effects. So ideally, we want to be getting our scoping opinion back in a timely manner. And just to note that despite you giving a scoping opinion, you still retain the ability to ask for supplementary information after the submission of the application. So if an issue arises later on that hadn't been thought of earlier in the process, it doesn't mean just because you've sent out a scoping opinion, you're limited. There is still that opportunity. But of course, those supplementary information requests aren't fishing exercises. They're there to help us make our conclusions on significant effects. Now, the assessment side of things, I'm not going to go into the detail of this slide in a lot of coverage, but between scoping and your activities of handling the EIA report, the developer and particularly their consultants are basically very busy. They're identifying what the environment is like. They might be going and doing some surveys. They're feeding assessment findings into the design process. Hopefully the design process is open and listening, and we can iterate between that assessment and design so we can potentially identify ways to reduce or avoid some of the impacts that might have occurred from the development and construction or at the operation side of things. All of this is considering whether these effects that they're identifying are significant or not, and there are expectations on the developer that if there are significant adverse effects, then they must consider the mitigation hierarchy, and they need to be defining monitoring measures as to how these issues might be monitored. And of course, what we monitor then becomes of interest of, is it the environment? Is it the potential mitigation to make sure it was delivered? Is it the efficacy of that mitigation to see whether it actually worked? They'll be making those decisions alongside the significance findings, all the data they've gathered, and that will be wrapped up into an EIA report. And these documents have become quite big and bulky, and that's perhaps something we can explore and discuss in one of our later sessions as to how we might get them more focused. Back to your activities and some of your key things that you'll be doing once you get the EIA report in alongside the application. So this is a critical area, and this is the majority of the definition of environmental impact assessment, which needs to have been delivered in order to remove that prohibition to grant consent. The majority of that definition is what's on this slide here. So the start of that definition is that the developer submits the EIA report. The rest of it, the consultation and everything else, falls to yourselves to undertake. So you need to ensure that that EIA report is consulted upon, and if any additional information is either requested by yourselves in terms of a supplementary information request, or if additional information is submitted by the developer after the EIA report has already been consulted upon, then you're going to have to undertake a further round of consultation. So that can happen sometimes. These, as I mentioned, these documents can be quite large. So we've maybe got an EIA report and they submitted it on the portal, and perhaps a number of the cultural heritage appendices never got uploaded onto the portal for some reason. Perhaps 6 weeks later, this is recognised and realised, and then they're uploaded. Well, that would then be part of additional information, and you guys would need to do the further consultation. There's specific parties that need to be consulted for minimum timeframes. We'll cover these in detail in a future session, but certainly the public and a minimum of 30 days, and the statutory consultees and a minimum of 30 days. So you can have multiple clocks running of 30 days at the same time that you need to be aware of, depending on perhaps when a notice went out in a newspaper for the public versus when you sent something to Historic Environment Scotland, and maybe it was a few days later that you sent the document off to SEPA. So you just need to make sure that all of those clocks have reached their minimum before we actually move on to the decision process, to make sure that we've dotted our I's and crossed our T's in terms of compliance there. What comes out of this process is we obviously get a whole load of consultation responses, and the EIA report, any additional information, and any of those consultation responses that recognise and refer to environmental issues as part of the project, they become this formalised concept of the environmental information. And that's something that you guys have to examine. So that infers, that you need to look at it in a degree of detail and, with a view of judgment in relation to it, rather than just a kind of review, as was previously stated. So you're examining that environmental information for a purpose, and that purpose is to reach your own reasoned conclusions as to what the significant effects are. And they might be different from the significance conclusions that are made in certain chapters within the EIA report, or they may differ from perhaps what some of the statutory consultees have raised. Ultimately, it is your job to weigh across that evidence. And therefore you have this power to request supplementary information if you feel it's needed to help you reach those reasoned conclusions. But this is sometimes where we need to be a bit brave or use our judgment to say, do we actually have the evidence to make a decision? Is this thing that I'm thinking of asking for as supplementary information actually going to help me move forward in making that decision or not? So we shouldn't just use those powers kind of automatically, because they do then put us back in terms of further information. Supplementary information is gathered, amendments made to the EIA report, and more consultation. So it can have a substantial effect in terms of the timeliness of the planning decision. And then finally, once you've examined everything, come to your reasoned conclusions, they need to be fed into the actual decision process. that decision process. You need to integrate those reasoned conclusions within that decision. So if that is moving from yourselves as officers to the committee, you need to be making sure that EIA content and conclusions around significance are set out in that committee report, making them aware it is an EIA development. And it's also very important to indicate within that you feel your conclusions are up to date at the point of decision. The EIA report might have come in some months before. The actual regulations expect your conclusions to be up to date at the point of decision. And of course, if you're going to award consent, or if that is what is being proposed, then there'll be a need to look at the mitigation and monitoring of the environmental issues in the EIA process and turning those into conditions. And then, as I mentioned, in post-decision, whether it's been granted consent or not, if it's an EIA development, then there is a need to make sure that certain environmental information, environmental findings are available. I believe the regulations say within the decision notice, but it can be alongside the decision notice. And again, we'll cover some of that detail in a later session. So the decision notice clearly goes to the developer. We need to also make similar information available to the public, to the consultees, and others who've been involved in the process. So that's a kind of, I guess, not quite a sting in the tail, but an additional activity right at the end of the process that we do need to be complying with, because it is part of the EIA regulations to make sure people are aware how the environment was considered in the decision making, and equally, if it is a case that it's been granted consent, what are the environmental conditions, design measures, etc., that have helped to manage those environmental risks of the project. So that takes us to the end of the kind of EIA process, and also the main slides for today. Just a quick learning review, and then we'll be moving on to our Q&A. So our aim today was to introduce you to EIA as planning officers, or for many of you, I suspect it may have been a degree of a refresher on EIA. So I hope you feel today has already provided you with some advice on the role EIA plays in the planning process, that those activities of the EIA process have got a bit more clearer for you. What is the difference between screening, is EIA required, and scoping? What, yes, an EIA is happening, what are we going to include in it? The information of which parties are involved in the key stages, and then a bit of a kind of a light dive into significance and its important role within the EIA process. So that completes our presentation for today.